If you are one of the controlling members of a closely held business, do you have a bullseye on your back? It may seem that way. Most states now recognize claims for oppression of the minority owners, whether they are corporate shareholders, limited liability company members, or partners in a partnership. These claims can expose the majority owners to personal liability and often have very negative consequences for the closely held business. My name is Jay McDaniel, and this is Closely Held. I'm a lawyer who practices in New York and New Jersey, and I head the business divorce practice group at the Weiner Law Group. Closely Held is a video podcast about the issues that most impact the owners of closely held businesses. Today, we're going to discuss how to defend you and your company from a claim of minority oppression. We will look at some of the key legal issues, some of the critical defenses, and talk about how the matters are likely to get resolved. If you find this information useful, please take a minute to like this individual podcast, become a subscriber to Closely Held, and share it with others. If you want more information, there are links to some of my articles below, along with my contact information. Feel free to reach out to me. Claims of minority oppression are asserted in any number of disputes between the majority owners of a business and one or more of the minority interest holders. It's not such a rare occurrence that the minority oppression claim is brought to gain leverage, and sometimes there just isn't a lot of merit to the claims as they're brought. The oppressed minority lawsuit is disruptive, it's expensive, and it can threaten the investments and the value of the majority owners. When looking at a claim based on minority oppression, you start with the law of the state where the business was formed. For example, lots of business owners set up businesses in Delaware or Nevada for tax reasons. It doesn't matter where they live or where the business is. The law of the state of organization controls the dispute. The law of the states are different, and the rules that apply to the different types of businesses are also different. In particular, corporations, which the law considers to be creatures of statute, on the one hand, and limited liability companies, which are partnerships created by the owner's contractual agreements, are treated in very distinct manners. It makes a difference. Drive from Wilmington to New York City, and each of the three states you pass through will have different laws. Delaware does not recognize a cause of action for minority oppression of shareholders. New Jersey gives minority owners of shareholders broad rights. New York recognizes minority oppression for corporations, but not for limited liability companies, and the minority rights of New York shareholders are more limited. While there are differences that exist based on the state law and the type of business entities, ultimately the claims and the defenses that arise in these cases are pretty consistent. I practice primarily in New Jersey, and we can use the law here as the starting point for our discussion. In New Jersey, and in most states that recognize oppression claims, the fundamental inquiry is whether the majority's behavior was contrary to reasonable expectations of the minority owner, usually at the time the business was formed. Reasonable expectation sweeps in a lot of conduct. It may mean an expectation of employment. It may mean an expectation of day-to-day participation in management. And it can also mean following the law and fulfilling the majority's fiduciary duties to the minority. Duties like honesty, loyalty, disclosure of information, and fair behavior. The majority owners can mount a defense to the oppression claim by demonstrating that the claimed reasonable expectations are not, in fact, reasonable, or that the majority was unaware that these expectations existed. Alternatively, they may argue that no reasonable expectations were violated at all. The New Jersey Supreme Court has defined oppressive conduct as objectively unreasonable when it substantially interferes with the minority's interest as shareholders. Now, that definition has been applied to limited liability companies, and you find similar definitions in other states. The first consideration in a reasonable expectation claim is the scope of the agreements between the parties. If there is a written operating agreement or a partnership agreement or shareholders buy-sell or corporate bylaws, any of them, that addresses what the owners should expect from the business, that agreement usually will govern. In many cases, the parties have other agreements that may be important and can govern such issues as employment and compensation, participation in day-to-day management, access to information, and a big one, distribution of profits or dividends. The most viable defense is often based on the written provisions of these agreements. The conduct that is reasonable is a fact-specific inquiry. It should not be judged from the subjective viewpoint of the parties, but from an objective assessment of the facts and circumstances. Building a case that the majority's actions were objectively reasonable is a strong defense. Those who control a business, whether as an officer, director, or a manager, or as owners of a controlling majority, will typically owe fiduciary duties to those who lack control. These fiduciary duties include a duty of loyalty and care that precludes misappropriation or waste of corporate assets, competition, or self-dealing. In order to protect themselves, it is possible that majority shareholders will need to provide evidence that they have in fact fulfilled these obligations of care and loyalty. One of the principal ways that a controlling majority will defend itself against claims of breach of fiduciary duty is to show that all were treated equally. The second defense is to establish that the challenged activity was objectively fair to the minority. The majority usually needs to demonstrate that its activities were conducted in a fair and equitable manner, taking into account the concerns of all of the stockholders, members, or partners. Expert testimony is often needed to establish that the conduct challenged by the majority was in fact fair. For example, the acquisition of an asset from a majority owner may be justified by showing that it was on fair terms. Similarly, the majority may be able to defend claims challenging loans or investments by showing that the terms were in the best interest of the company. There's another area of defense that comes up frequently in defending a minority oppression claim, and that's the application of the business judgment rule. The business judgment rule provides that those in control of a business, the majority shareholders, the directors, and managers, are entitled to a presumption that the actions that they take in the management of the business and in good faith are in the best interest of the business, and that they won't be second-guessed by a court. Many of the claims brought by minority owners alleging mismanagement will be subject to a defense that they were within the discretion of the majority as a result of the business judgment rule. The big distinction is usually whether there is a self-interest. If the majority has a self-interest, if they're on both sides of a transaction, then it's more difficult to mount a defense around the business judgment rule. Typically, the court is going to require that the majority show that its actions were objectively fair. Now, maintaining corporate formalities is imperative in ensuring sound corporate governance. Adhering to proper procedures when making significant decisions, such as maintaining good records of board and shareholder meetings, can also serve as a strong defense in cases where a dispute arises regarding the provision of information to minority shareholders. A defense argument may arise that all necessary disclosures were, in fact, provided. In some circumstances, the majority shareholders may contend that actions which appear to be oppressive emergency or as part of a genuine business objective. Finally, there are defenses of ratification, consent, and waiver. If the minority member approves some action that he or she now challenges as oppression, the court may well reject the claim. In much the same way, a minority member who knew about the conduct that's now part of the minority's oppression claim, but did nothing in response earlier, may find that the claim has been waived. It's critical, when confronted with a minority oppression case, to respond promptly and aggressively. Often minority oppression cases begin with emergent applications, and the decision that a judge makes during that first week of the litigation may set the tone for the entire lawsuit. The majority usually does not want to wait to be sued, and often begins with a lawsuit of its own. Thanks for listening. You'll find more information at some of the links below. We have other video podcasts that you may also find useful. And if you have an issue, don't hesitate to reach out to me. My contact information is below the video.